Welcome to this free immigration help channel. Today is March 31st, 2023, and we are getting into the volume 48 of me answering your comments and immigration related questions. Before I begin, I'm going to mention, just like I always mention, I am not an immigration attorney. This is not a legal advice. All the information that I provide in these videos on this channel are directly from official government sources like USCIS and of course the Department of State. So without further ado, let's start with the very first question comment from Evelyn. Neptune, I need a I-94 form, I'm assuming. So yes, on the video, I-94 form. So whenever it comes to I-94 form, just follow the instructions in the video. You'll have to go to the CBP website and fill out your information. And hopefully your I-94 will come up, the electronic version of your I-94. However, a lot of times, a lot of people unfortunately are experiencing problems pulling up that form online. So if that's the case, I actually do have a video specifically on that situation. If the I-94 is not coming up, I have a video on how to contact CBP, how to file a request to get that information retrieved. So when you get a chance, check it out. It is uploaded on this channel. I'm gonna post this right here so that you're aware that I'm answered your question. And let's move on to the next comment from Hagos Tades. By the way, I'm sorry if I'm mispronouncing the names. Is yearly income before tax or after tax? Great question, Hagos. So whenever it comes to being a petitioner, being a sponsor on I-130 petition, when you're submitting your tax returns, whenever you're submitting your tax transcripts, it's always net income, which means it is after all of the taxes are already taken out, all of your expenses are taken out of your income. So you have the gross income, everything that comes in, and then minus all the expenses, minus all the liabilities, net income. And that's what you're showing. All right, so we're gonna move on to the next question comment from H Digitally. Hello, sir. How long does it take after case was sent to the Department of State? So I-730. So I-730 is the petition for asylee refugee relative, and I'm gonna actually go to the form itself just to double check. 730. And there you go, refugee asylee relative petition. So once it is approved, it's very similar process. In fact, I think that's why they named it 730 after 130. It's very similar process to the petition I-130. Only I-130 petition is for legal permanent residents and US citizens to petition for their relatives. I-730 is for refugee asylee who had their status, refugee asylee status, already approved, all right, by USCIS. That's the form that you use in order to petition for their relatives. And similarly, once the petition is approved by USCIS, which again, you probably already know, processing times for USCIS approval, it is transferred to the NVC for further processing. Whenever it comes to further processing with the NVC, the process is a little bit different for the 730 compared to the I-130. There is a little bit of time, there's a little bit of delay that they have to wait. Obviously there is a time where they have to schedule the interview for the local US embassy. So overall process, typically on a typical, you are looking somewhere 6 months to 1 year. However, considering that how much backlog there is at the moment with pretty much all of the petitions that are out there, even those that had current availability, as we recently discovered from the Visa Bulletin April 2023, I would say you might be looking at a longer. But if you can let me know how long you have been already waiting, I could do a little bit more research and dig into it and see if I can provide a little bit more information for you. All right, let's move on to the next question coming from Barbie Dream. Hi, sir. What is the email address to send the documents? Thank you for your help. Okay, so that question was posted on expediting USCIS case. Here's the thing, with whenever it comes to the USCIS, it's a little bit different compared to the NVC, because for the NVC we have just the National Visa Center, right? If your case is already with National Visa Center, you just email them directly and that's it. Whenever it comes to the USCIS, depending on what kind of case you have, it can be in USCIS processing center, it can be in USCIS field office, it can be in an asylum office. So depending on which case we're talking about, that's the guys that you want to contact. And sometimes the email for those guys is just not available. So I wouldn't look for a general email for USCIS. If you want to submit a case inquiry on a particular case, you can do it through USCIS website. But if you are trying to contact a certain either service center or field office directly, which is what you should be doing depending on what kind of case you have, you would have to pull up the information specifically for them. And a lot of times, like I said, they don't have the email, so you would probably have to send them a letter, actual physical letter. That probably would be the best case scenario, more reliable than the email. But again, if you want to inquire about the processing times, if it's taking longer, I would use the case inquiry form that again is found on USCIS. And let me actually really quickly show you how to do that. We're going to go to tools at the very top here of the navigation menu, and then we're going to go to case status online, and then we're going to scroll down here and you see submit case inquiry. So we're going to click on this and it will give us the page. You'll have to select the reason why you are submitting this inquiry. A lot of times this inquiry is submitted if the case is outside normal processing times. And that's it. Here's your form. And basically this goes based on what receipt number you enter, what form it is, it already goes to an appropriate service center or field office. All right, so this is going to be very helpful, probably better than just, you know, sending to a general email or something like that, because most of the times those emails, they just go into nowhere. But if you want, you can provide a follow-up comment with a little bit more information, and I might be able to provide a little bit more detailed answer. Just make sure, and it goes to everyone, please don't respond to my comment here. Just submit a separate comment, because if you respond to my comment, YouTube does not send me notification, and I don't see those responses. For whatever reason, I don't know why, but this is the case for now. All right, let's move on to the next one from Kiki Johannes. Hi, do the forms needed to be sent along with documents, photos, copies of birth certificates, passport, etc.? My fiance said he doesn't find anything that says he has to mail the I-129F forms with those documents. Just a note saying additional will be asked if USCIS needed it. Is this new regulation in 2023? Great question, Kiki. Actually, I am pretty sure, I'm not pretty sure, I know for a fact that you do have to submit all of the documents, at least the initial evidence, like birth certificates, obviously, you know, the intentions, some kind of proof showing that, you know, because this is fiancé visa, so, you know, if your fiancé is filing for you, showing the plans that once you come into the United States with this fiancé visa, you guys have actual intentions to get married. All of these things, the proof for all of these things, it has to be submitted with the initial application. And we actually gonna go, I'm gonna use this again as an opportunity to demonstrate navigation on the USCIS website. We're gonna go into forms, and this is where you want to get your information from. This is where you want to double check everything that you read online, everything you find in the forums, you know, if you're doing general research, right here on USCIS website, this is the most updated, the most legitimate information, because this is the government website. All right, so we're gonna go to all forms, and then you can either scroll down, it's all alphabetic numerical order, or just type in 129, and it will give us a few 129 forms. We're gonna click on F, there we go. And let's see, so we got our form itself, we got instructions. We can probably look in the instructions, but there we go. We have checklist of required initial evidence. There we go. We're going to click on that. Did you provide the following? Evidence of your US citizenship, a copy of your birth certificate, or a copy of naturalization if your fiancé was naturalized, a copy of form, consular, that's all the showing the US citizenship, so it's pretty much the same thing. But also you have to provide the evidence you or your fiancé legally terminated any previous marriages, if there are any, if applicable. One color passport style photograph of yourself and one of your fiancé, okay. Evidence of legal name change, if applicable. Evidence to support an international marriage broker. if applicable, whatever that is. If you are petitioning to classify your fiance as K1, non-immigrant, which I'm assuming that's going to be the case, evidence you and your fiance intend to marry within 90 days of their admission, of the fiance admission into the United States as a K1, evidence you met your fiance in person within 2 years of filing your form I-129F, that's one of the requirements. If you're petitioning to classify as K3 non-immigrant, spouse, which I don't think this is the case for you, but so anyway, this is the initial evidence, which means that this stuff, it has to be submitted together with the application, with the form I-129F. Now, of course, you can send just a form, and I did a separate video, I don't remember what it's called, but you can submit, technically, for any application or petition, you can submit just a form and then wait for USCIS to review it and then send you a request for initial evidence, and then you send separately the initial evidence. So as you can imagine, it takes extra time, it takes extra money, and I wouldn't recommend doing it. It's always best to submit the case as strong as possible. Actually, that's, I think, what the video is called, submitting the USCIS case, making the USCIS case as strong as possible. I think that's what it is called. But the idea behind making the case as strong as possible is submitting the whole package. So once it is in front of the USCIS officer on their desk or whatever, if it's online application on their computer, and they open it up, they have everything they need to make the determining decision. Say, okay, they provided this, they provided that, everything's good to go, I reviewed it, good, approved, or whatever. You get the point. Or if it's the petition that goes through initial review, that everything is there, they initially review it, and then they transfer it to another officer who will actually make a decision whether to approve it or decline it. Some of the forms, they go through those stages. But again, to answer your question, definitely everything needs to be, there is a choice not to submit it. It will be requested later, but I definitely do not recommend it. Submit everything, make the case as strong as possible. All right, let's move on to the next question coming from ya boy Martin. I'm American and married my wife in Nepal a year ago. Yes, Martin, I remember. I've been here in Nepal for 3 years now with a visit back to the States about a year and a half ago. I'm about to send in my I-130 online, but I want to make sure my answers make sense regarding address. I know that domicile is a big deal, yes, and I'm quite sure that won't be a problem. I have filed taxes every year, active US bank account with money in and out, mail in my name regularly coming to my address, valid driver's license. Martin, you're good. My question is, if I answer the question 11, is your current mailing address your physical address? As yes, how do I truthfully answer the question later on 59? Provide the last address at which you physically live together with your spouse. Yes. If I say I've lived with her here in Nepal for a year, won't that be conflicting to my answer that my physical address is in the States on question 11? Won't that mess up my domicile? Thanks in advance for your help. Martin, you're very welcome. I completely understand your worries about this. You know, when you're starting the immigration process, it's always like this. It's pretty stressful, and this kind of anxiety / excitement is completely normal. So, with my answer, I will try to give you the best of the peace of mind that I can give you. Okay. So, whenever it comes to USCIS, right, the initial petition I-130, if you look at just I-130, forget about the whole everything Department of State, just USCIS, just I-130. Technically, there is no such domicile requirement, all right? If you go to USCIS, and if you go to the forms and look through I-130, through the instructions, through the whatever, you're not really going to find anything about domicile requirement or where you have to be or can you be outside and so far so forth, for US citizen at least. But this domicile requirement comes into play whenever the case is transferred to the Department of State, because the domicile requirement is for the petition whenever it comes to the petition being a sponsor. Specifically for the form I-864, I think the let's see, let me actually try to, this is gonna be interesting to find, but we will try. I'm gonna leave the visa bulletin here. We're gonna open up US visas. We're gonna go to immigrate, family based, and let's see if I can find this FAQ, immigrant visa affidavit of support. Aha, I think this is it right here. So domicile, there we go. Okay, can a US citizen there? All right, this is it. Okay, so what does domicile mean? Domicile is the place where a sponsor has his or her principal residence with the intention to maintain that residence for the foreseeable future, which obviously 100% for you, in your case, it is United States of America. You have absolutely no plans to continue living in Nepal, or you're not planning to buy a property in Nepal. And even if you did, honestly, you still are not planning to sell whatever you have, maybe a house here or whatever your living situation is in the United States of America. Despite the living situation, you have obviously your address, you have your taxes that you're paying, you have your driver's license, so you are maintaining that domicile. Basically, this is what it is referring to. To qualify as a financial sponsor, a petition must be domiciled in any of the states of the United States of America, which again you have the permanent, not the permanent resident, the driver's license in your case in one of the states. So that kind of solves this problem right here. Any territory, a lawful permanent resident sponsor also must maintain his or her legal permanent residence. Well, that doesn't have to do anything with you. A sponsor who is not currently living in the United States may meet the domicile requirements if he or she can submit evidence to establish that any of the following conditions apply. All right, the sponsor is employed by a certain organization as defined below. If you're employed, if you have an employer in the United States, you can submit that. That would be helpful. The sponsor is living abroad temporarily, which is the case for you, and has maintained his or her domicile in the United States, which is exactly the case for you. The sponsor intends in good faith to establish his or her domicile in the United States no later than the date of the intending immigrant's admission to the United States, which, again, even if you didn't have domicile, you still do plan once your spouse in Nepal, once she gets her immigrant visa, obviously you guys gonna come here. So you meet all of this stuff right here. And again, if the petitioner doesn't have domicile in the United States, can joint sponsor file I-864. So again, this is specifically referring to the form I-864, which is the affidavit of support, which you will only get to when the case is approved by USCIS and sent to the Department of State. So you have absolutely nothing to worry about. In your case, you are good. Now, whenever it comes to answering the petition, the question themselves, we're gonna go to the petition. I'm gonna open the paper version of it, and we're gonna scroll down. Let's see. So we got our mailing address, which here you will put your address, obviously in the United States where you're getting all your mail, probably your main address, your home address, however you have your situation set up right now. In the address history, however, in the physical address number 1, you can put your current address in Nepal. And then in the physical address number 2, you can put your same as mailing address here, which is, you can still put date, it says date from, right? And you can put the date from is going to be from whenever, and then date 2 present, because it is also your address. Yes, you're not physically at the moment there, but it is still your residence. You did not get rid of it. It's still your place where you live. So you can put present here as well. And with that kind of information here, that answers your concerns about the 59, and we're going to scroll down to this, where you're actually putting the last address where you lived with your spouse. And there you go. If filing for your spouse, provide the last address at which you physically lived together. And here you can put your address in Nepal, which is a good thing. It shouldn't worry you. It, on the other hand, should give you reassurance and encouragement. Why? Because by putting that Nepalese, I think that would be the right word, probably. If not, probably not. I don't know. But yeah, I'm an immigrant, so my English is not the most fantastic English. But by putting that address in Nepal here, you are basically solidifying, for whoever is reviewing this application, solidifying the reality of your marriage. And it's another very important aspect that a lot of people have to keep in mind whenever they're petitioning for their spouses, because when you petition for your children, for your parents, right, for your brothers, sisters, you only need a few things to establish the relationship. You just, birth certificates, and that's it. With marriage, however, unfortunately, there's a lot of immigration fraud whenever it comes to marriage. People do these things, for money, to just get the green card, and that's it. Unfortunately, sadly. But you are putting you're showing that you are there in Nepal for her. So that if anybody reviewing your application, if they have any doubt whether the marriage is real or not, that right there shows that it is as real as it gets. Why? Because you left everything here in the United States and you went there for her. That's great. So hopefully, Martin, I was able to give you some more reassurance. But again, if you have any follow-up questions, absolutely do not hesitate to ask. Again, I will be more than happy to answer. And I appreciate you watching, everyone watching and asking questions, because without you asking questions, I wouldn't be able to do these videos. So it means a lot. Okay, let's move on to the next one from Naveed Malik. Thank you so much for detailed answer. Really appreciate it. You're very welcome, Naveed Malik. Thank you for asking, and thank you for watching. I'm really glad this was my response was helpful. Okay, moving further to Pranvera Dine. Sorry if I'm mispronouncing. Hi, it has been 7 years since I made my spouse's card for the USA. I have made the other papers and the payment since 1 year before, but the date of the interview is not coming. I please you so much. When will the date of the interview come? I'm devastated. The boy is unmarried. Please help me. I'm very sorry, Pranvira, that you're dealing with this. So let me think. So sons. I made my son's cards for USA. Okay, so hi. Has been 7 years since I made my son's cards for USA. So you have applied I-130, you submitted a petition for your son. I made the other papers and the payment since 1 year before. Okay, so I'm assuming 7 years you submitted the I-130, and a year ago you dealt with the NVC, but the date of the interview is not coming. Have you been documentarily qualified with NVC already? Meaning that after you submitted the payments, after you submitted all the paperwork the second time, the year ago, the recent one, right, with the NVC, have they responded to it and said, okay, you're documentarily qualified, everything is good? So that's number one question. If you can follow up, I would really appreciate it. Now, let me take a look at the visa bulletin. If you've been waiting, so 7 years, and then, okay, so it's been 7 years. So I think the total is 7 years. So after 6 years, they sent you the NVC portal. They transferred your case to the NVC. So 7 years, let me take a look. So I don't know which category, because you didn't say whether you're US citizen or legal permanent resident, but let's see who's waiting for what. So category F1. Okay, let me just give you different categories for children, right? So if you are a US citizen, and if your son is unmarried and over 21, then he falls within the priority 1 category. Okay, as of right now, April 2023, there is a delay of about 9 years. Okay, 9 years. So you've been already waiting for 7 years. So about 2 more years, roughly. About 2 more years for the immigrant visa to become available for your son. 2 more years, roughly. However, let's move on to the next one. Spouses and children of permanent resident. If your son, I don't think your son is within the category, because they only about 3 years delay. He should have already gotten it. So I don't think that's the category of your son. Now, F2B, that's another possibility. Unmarried sons and daughters of permanent residents. So if you are a permanent resident and your son is unmarried and 21 years of older, so the same as category 1, only for permanent residents. If you are a permanent resident, then they have a delay of about 2015, 7, 8. About 8 years. About 8 years. And this one is 9 years. And this one is 8 years. Did I say 9 years here? I feel like I said something else. Sorry, my math is just a disaster. So this is when people file. This is final action. Never mind. This right here is when people file the initial application. So as of for category 1, we're looking at about 7 years delay. For category 2, sons and daughters, unmarried, over 21, we are looking at about 6 years. 6 years delay. So I'm thinking your son either in this category or this category. But there's another option. If your son, if you are a US citizen and your son is married, then he falls into F3 category, priority 3 category, and there is a much longer delay. There is there's a lot of time, 14 years delay. So please let me know if you can, submit a follow-up comment, and let me know what your status is. Are you a legal permanent resident or are you a US citizen? And also let me know your son's situation. Is he married, unmarried, 21 older or younger? And I would be able to provide a little bit more details, but you already seen all the categories that there are and how much approximately it takes. So if he's within one of these categories, you're probably looking at about 1-2 more years for the immigrant visa to become available. If he's in a third priority category, if he's married, then you're looking at, unfortunately, much longer. It's unfair, it's a disaster, but that's just a bureaucracy that we have to deal with at the moment. So if you can provide additional information, I'll be able to provide more details. All right, let's move on to our final question for today, because we're getting to the 30-minute mark. It's from Simon Williams. Good evening. Just listen to volume 47. Simon, thank you very much for listening. Where you answer my question, but wanted additional information for a better understanding. Yes. Sorry about that little information. No worries at all. My bad. So it's my dad who had filed for me. He's a US citizen. So I'm F1. Okay, perfect. And my priority date is June 26, 2017. As I said, received summary information that my case is with NVC, but have not received a welcome letter. Just asking how long from now do... I see. Okay. So USCIS transferred your case to the NVC. They approved it on their side, but you did not get any welcome letter from NVC yet, basically giving you the access to the portal. So let's see why. Because I think I might be able to kind of give you an idea of why this is happening. And sometimes for whatever reason, I'm not sure. It's some of the cases, they give the welcome letter right away. They give you access to the portal right away, and then you can get documentarily qualified. And once you're documentarily qualified, then you just wait, years. That's why we have, in the visa bulletin, we have this graph right here, final action date, all right? But sometimes NVC, before they give you the access to the portal, they wait closer to the availability of the immigrant visa. And I think that is the situation in your case. They are just waiting for the immigrant visa to become available, closer to the availability of it, and then they will give you the access to the portal, which is not a bad thing at all. You shouldn't worry about it. In fact, I would say maybe it's even a good thing, because they already, once they give you the access to the portal, they give you that access to the portal with the awareness that the immigrant visa is going to be available soon. So you can kind of estimate that by the time you are documentarily qualified, they can already process it further and schedule your interview with the US Embassy, which is not a bad thing at all. It's just processed a little bit different to some of the cases where they allow their, get them documentarily qualified way before the immigrant visa is available. So let's take a look at the initial filing. You said your initial filing was June 26, 2017, your priority date, initial filing with USCIS. And if we look at the visa bulletin as of April 2023, the priority dates that are the immigrant visa is becoming available now as of April 2023 is in August 2016, which is almost practically exactly 1 year before your priority date, which seems like you will be getting your access to the NVC portal very, very soon. I would say I wouldn't say within a year, I would say within 6 months, you should be getting access to the portal. Why? Because it's only about a year until the availability of your immigrant visa. So you need to still deal with all the, all the application fee for visa. You have to deal with, well, your father has to deal with, who submitted the petition. He'll have to deal with the affidavit of support, all that good stuff in the NVC portal. So they have to allow for additional time for that. So I'm thinking within 6 months you will be hearing from them. So I really appreciate you following up. I hope I was able to give you a little bit more information, a little bit more insight, and that was helpful. Everyone, thank you for watching. Thank you for asking your questions. Again, if you have any follow-up questions, don't hesitate to ask them. Just make sure to submit them in a separate comment. Don't respond to my comment within your comment because I don't get notification for these. But really appreciate your time. As always, God bless you all, and I will see you in the next video.